Hey y'all, let me know if you can hear me. I'm back. Told you guys I was gonna be back in a couple of hours. I try to be a woman of my word. Hey everybody, I'm starting out with the documents. We're not even gonna have them type of problems. Hey Alice, Blue Child, hey Cupcake, Kathy, Ben Child, Cupcake. Oh, I'm glad I was just in time. Good afternoon, good afternoon. Armin, good afternoon, Octavia. You guys are piling on in here. Thank you, thank you, thank you. All right, yeah, I had to like reboot my computer. I'm like, this must be a computer issue, but I get it fixed. I done had a computer for like 1,000 years. Hey, everybody, Danielle. Hey, can't nobody say Pam like Thais say it though. Sabrina, hey. So yeah, quick recap, you guys. If you have not watched the other video, you guys go watch the other two because they were fire. If I must say so myself, we were talking about Bishop Whitehead and his Connecticut properties, and he had a court hearing just recently, and I attended. So I took the other video down, so I'm gonna go ahead and talk about that real quick. So last Saturday, I did a video where I talked about the foreclosure of the block that he says he owns in Connecticut. Well, I came across some documents showing the foreclosure and also that the loan company was requesting a receiver because of the condition of the building. If you guys follow him at all on any of his pages, I don't really follow him, but I go over there and I'm nosy sometimes. In his stories, Monday, suddenly he decided he wanted to go over there and be in front of the building. And he told people, don't believe what other people say, I guess showing that he still owns the building. I never said he didn't own the building. I just said it was in foreclosure and he was having some issues. So let's be clear with that, Bishop, because I know that you're probably over here watching for you to rush and go over there on Monday. So the reason why the loan company wanted a receiver was because the shape that the property was in. So that was the crux of on yesterday morning at 10 o'clock and at 12 o'clock. It was two different hearings. I was able to see and view the hearing that he was in, and he did show up to the hearing. And the purpose was the like I said, the loan company wanted to get a receiver because of the condition the property was in. They wanted somebody to be able to come in and basically take over the property and make whatever repairs because there were safety violations because there were no fire escapes on there were a lot of missing fire escapes. And we'll be going over that with the documents in a minute. So apparently on about October 12th in the evening, Whitehead went and got him an attorney. And that's why he ended up showing up for the hearing. So the attorney tried to postpone that hearing. The judge basically was like, no, because we already gave you a continuance before for a couple of weeks. We're not going to give you another continuance. So that attorney did the best that he could. So Whitehead basically said, as you see on the screen with the motion to dismiss, he filed a pro se motion basically, representing himself. But the judge did mention he knew that an attorney probably drafted this, but they didn't know Connecticut law. So this is a motion to dismiss where he's basically saying, as you see, for lack of jurisdiction over the process and sufficiency of service of process. He basically was saying that he was not properly served. So that's the background. I'm sorry, y'all, if you missed it, because I got to get right into it. So as you guys know, if you watch the other live, and I didn't even show this, but this is the affidavit of service from the person from the mortgage company that served him. So this was the affidavit. They said that on October 27th, Jane Doe, who was a member of the household but refused to give their name, This is how this person was described: 46, 5'9", 165 pounds, blonde hair, female, race black. All right. Then, so he swears, this person, this process server swears, they said affidavit of due diligence. They basically say that they gave the summons, the complaint, and the list pending. They served upon member of the household, Jane Doe. The name was refused. Server believes the Jane Doe who refused her name to be Asia K. Dorsey Whitehead, wife of Lamora Whitehead, based upon review of an internet search and review of social media links, which shows a picture of a woman and indicates that she is Asia K. Dorsey's Whitehead, wife of Lamora Whitehead. The woman in this picture annex is the Jane Doe that was served with the papers noted above. So essentially, this was the picture that the process server attached. And that's the person that they saw when they did their process of service. Sit that right there for 1 second. But let's go back to the motion. The motion to dismiss says, I hereby move to dismiss this action filed by the plaintiff for lack of jurisdiction over the person and insufficiency of service of process. Defendant's appearance is limited merely to contest this court's jurisdiction over him. Defendant is not the resident of the state of Connecticut and has not been served process. Defendant's motion is supported by the attached affidavits and memo of law filed therewith. And then attached to this motion to dismiss is an affidavit from Asia Dorsey's Whitehead. She says, under the penalty of perjury, she swears to the truth of the following. The statements below and herein are based on her personal knowledge. She has her full name. I'm not a party to this action. She does say that she is his lawful husband, that's her lawful husband. To all of you guys that were, wondering, she said this is her lawful husband. Defendant and I reside together in a domicile located in Paramus, New Jersey. At no point in time has the summons and complaint or other papers in this action been personally delivered to me personally. I am not an agent or registered agent for defendant Lamar Whitehead. I am not an agent or registered agent for defendant Whitehead Estates. I am the only other adult or person of age of discernment who resides at our home. I am not 46-year-old age. I'm not 5'9" or 165, and was not served via personal delivery or otherwise on August 27th with the summons, complaint, and list pending as falsely sworn by Joelle Sanchez. So she said the process server is lying. She swears under the penalty of perjury that the foregoing statements are true and correct. So anyway, let's move on. So also that day, so we're getting back to the hearing. So let's go back to this hearing. So me and another intellect, we had the pleasure of being there for this hearing, and we watched it as it was going on. So just to give you guys a recap, I get my little notes or whatever. So he gets on there again. He had just got him an attorney the night before. Of course, he was trying to talk, and the judge was like, well, sir, you have an attorney. That's your point of your attorney. Maybe you should let your attorney talk. So he, the attorney said, yes, I am the one to be talking on your behalf, da, 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 da. But, he did just come on the day before. So I guess, Whitehead would know probably more than his attorney at that time. So what Whitehead was saying was that he had started, basically that he got an extension to make those repairs of those fire escapes that are in those buildings that I have on here. So he said he got an extension from the fire department. Now, this was a receivership hearing. So again, this was just because they wanted to take over because they were concerned about, they wanted to get the rents too because he's still in default. The judge made it clear he still owed that $4.5 million. So he was currently in default. but they wanted to take over because of the safety violations of the building. Whitehead contacted the he testified basically. Well, I don't know if it was testified, but he said on the record that he contacted the fire marshal and they gave him some until sometime in November to be able to make all of these repairs. So the judge was like, was it verbal? Because we gonna need some type of documentations to justify that that really occurred. So he asked, Whitehead asked, could he get off of the hearing and go talk to his attorney? So they muted, they took a break from the hearing and they went and they talked. So apparently Whitehead faxed over some type of email or something where he had until November to make the repairs. The judge made it clear. Now this just has something to do with the repairs. So are you still in default? And the attorney for the mortgage company said yes, he's still in default as of today. So then he said, well, has he made any type of repairs? Now, this is the pictures that I'm showing you that the attorney for the insurance company, I mean, not the insurance company, for the loan company said that they got these pictures the day before. They had took them the day before the hearing. So this is what you're looking at, the pictures. So if you let me take myself off of here. So if you look at here, you'll see these are where those wooden panels are where the fire escapes are supposed to be at. So he said he couldn't take them. Obviously, there's a lot of buildings. He had just literally took them the day before. So this is what he was able to get, he said, without trespassing, because he had to, get what he can get from the distance that he had to be without being considered trespassing. So he told the judge, no, he has not made these repairs. There's still no fire escapes, as you guys can see. So Whitehead responds and says, well, his attorney said, well, he just sent me pictures from yesterday and they're bait stamped for yesterday afternoon. And these pictures show a whole different type of a picture. And they also show a different, basically, they show some type of fire escapes. The pictures that he gave his attorney and faxed over, there were apparently some fire escapes. So the attorney was like, well, this isn't the same pictures. He just faxed me of what this attorney from the mortgage company just gave the court. Now, the attorney from the mortgage company actually filed this. So the judge had it. So the judge is looking at it like, unless these are glass walls for fire escapes, I don't see no stairs. I don't see nothing on here. So what are you talking about? And the attorney said, well, these pictures I have are totally different. And so that's when the attorney for the mortgage company said, well, I couldn't get all the buildings, so maybe some of the buildings had them that he just gave you, but these are the ones I was able to took, and I took them yesterday. And I can tell you the time and whatever that I took these pictures. So as I showed you guys earlier, I have the person I watched with from Connecticut. She went by there this morning. And when she went by there this morning, we can get some even more updated pictures. And I'm going to show you on my phone. So those are what we were looking at, before my stuff was acting up this morning. I told y'all it's a lot. It's a lot going on here, y'all. So this is the ones from this morning, as you see, literally this morning. But nevertheless, the court gave him grace and mercy and said, well, because the fire department allowed you more time, we're going to allow you more time, and we're coming back in November. So that was the first hearing. And then the second hearing, but what I did notice, though, is they were very, very specific on calling him Bishop. Like he put on, how you put your name if you go on Zoom and it's that Bishop Lamar Whitehead. He made sure he put Bishop. So when they would accidentally say Mr., they would correct themselves and say Bishop. So it's almost like it gave him this extra sense of favor because you were considered a bishop, which a lot of us are in high reverence of. Most people are in high, and this was an older judge. So I'm sure he probably knew the title of a bishop and what that title means. So in the afternoon, he had another hearing because there's an outstanding water bill. And so they wanted a receivership and they wanted to be able to collect the rent until that outstanding water bill. Now, this is the actual city. So essentially, he was trying to work this out with the attorney for the city before the hearing. They couldn't come up with an agreement because he felt like it wasn't his bill. It was on the building before he got there. And he's been going back and forth about it. Oh, he said he wasn't served too on that one. But he made sure he said, I think they posted on the buildings. So I think he was like, well, I know they probably posted on the building, but somebody could have took it down, but I never got it. So he said he never got served this as well, just to be clear. So, anyways, for that one, him and the guy were trying to he's because he said he never got served that too. The judge was like, well, since he said he never got served, we'll give you guys time to kind of talk about it and come to an agreement because he wasn't agreeing with the amount. One, he was saying that it was overly excessive. A couple of $1,000s were added, but the judge had explained to him when the city has to sue you for that, they want their attorney fees and they want their costs, and they are entitled to that. So, and then he told him if you prolong this and don't pay it, what's probably going to happen is that you're going to end up having to pay way more because you're going to have to pay for the receiver to come in and do this. So, anyway, both of these cases are coming back in 3-4 weeks in November, and the court is expecting an update. And this has absolutely nothing to do with the actual default of the money. This really was to try to get control, the first hearing anyway, to get control because of what you guys see right here. So it looks like they may not have no stairs or fire escapes for a couple of more weeks. So I'm gonna look at these comments before I go over. Hopefully I wasn't moving too fast, but yeah, I actually saw that hearing and was able to view it. And I will say his demeanor was I guess I expected a different type of a demeanor, but I think he was pretty, I don't want to say humble, but he was, he was appropriate for court. I can't report like he was, trying to overtalk, undertalk, whatever. He was appropriate, your honor and yes sir and all of that. So he was appropriate while he was there. He was pretty chill. He has a bunch for rent signs in the yards of the apartment building. He's trying to collect what he can while he can. So you guys hear that? Thank you so much for the super chat. I appreciate it. So let me catch up on some of your comments. I know this is a lot. Hey, what up, though? Mm, yeah. Thank you. See, I'll be over here working. I know it's been a week, but I made sure I was gonna make it good whenever I came back. It's been a really, really hard week. I had a whole lot of fires that I had to kind of burn out and get a lot of work done. Welcome to everyone. Welcome to everyone that has just subscribed. Please like, please share, please subscribe if you have not done so already. And shout out to my Connecticut Connect because we had so much fun. I'm gonna have to take a couple of y'all on to the next hearings. Not like we was actually in the building, but you know what I'm saying. Like some of y'all gonna have to watch because when I tell you, we were like, did you hear that? Did you see what happened? It was really fun. I've never had that with anybody else, like to be in the gallery and get to see the perception of other people. Okay, question. If he wasn't served, how did he know when to come to court? Good question. He said that he didn't know until the court called him. But if you guys were to see this affidavit, the affidavit from his wife was signed on the 10th, which is Monday. So unless he's trying to say my video was what gave him the heads up, maybe that's what he's saying. Because I did my video Saturday about it, I believe. And the Thursday was when the New York Post came out with their information, but they didn't have it as thorough as this. They just were talking about him trying to collect rent and the condition of the apartments. So maybe that's what gave him the heads up if he didn't know already. I think that's what he's going for anyway. You said you love to watch it. Hey, email me or DM me. I'm telling you, because she said it was only me and I think we were the only ones on there. I think it was only two people watching. That's what somebody was saying. Wood and fire escape. I was just asking my husband because he's from that area. I'm like, do they got wood and fire escapes over there? That's interesting. Maybe that's just like what you do until you like complete it. Maybe I don't know. Y'all help me out. You said, yep, it was just we had so much. I mean, she has been like, we were like, wow, really? He showed up. We didn't think he was gonna show. We saw his name, he was on there. So, anyways, on Monday, he basically was to me, I felt like he was saying that I was making this stuff up because of what he was saying. But as you guys see, there really was a hearing and there really are documents. So if you think this was made up, then you just might want to go talk to some other people beside me, like the court. Cause let me see. This is what he said. This is a clip from Monday, y'all.
Working, y'all.
Ooh, that's
Stop believing everything people talk about. Stay focused. Whitehead Estates, baby. That's right, we in the building. Whitehead Estates.
so that's why he was out
Working,
there
y'all.
working.
Stop believing everything people talk about. Stay focused. Whitehead Estates, baby. That's right, we in the building. Whitehead Estates.
No, they weren't talking about the foreclosure. It was kind of a immediate hearing where they were specifically trying to get a receiver because they already knew that this the condition, as you guys seen, of the building on the outside. We're not even talking about what the renter said on the inside. I'm sure that's their own type of inspections that the city has. But the fire department, they come and make sure you're in compliance, and it's a lot of looks like there's some fire escapes that aren't there. So they were there all week while he was there. It appears because, from my understanding, some of the material is still out in the yard as we speak and sit here today, this Friday, that he was working on that all week or having someone work on it. I doubt he was hammering anything. Mm, all money ain't good money. Whitehead Raggedy Estates. So that was my experience. I just wanted to let you guys know that was my experience at the hearing. So a lot of people also let's kind of phase into the next thing. A lot of people also was wondering about the Anderson hearing. So the last time I talked to you guys on the Anderson case, we know that Whitehead hired that attorney, the same attorney that sued Larry and sued Jives. He hired that attorney to represent him and he did a motion to dismiss. Well, what happened is Anderson's attorney did a reverse Uno, right? So let me tell you what Anderson's attorney did. He said he is not about to be playing games. So we about to read this document right here. One second, one second. Let me get back to my documents. So Anderson's attorney filed a nice brief, right? I like good stuff. So this is the preliminary statement. He's requesting a show cause hearing, which I ain't gonna tell you the outcome yet, but he requesting a show cause here. Y'all get excited about stuff like this. So it says this matter arises out of an attempt by a bishop to defraud one of his congregants of money. Now, this is, of course, the allegations of Anderson. We don't really view this as fact. This is his rendition. Okay. Defendants absconded with plaintiff's life savings under the guise that they were going to assist her in securing desperately needed housing. Instead, the money was actually put towards the purchase of a lavish personal home and other real estate for defendant Lamore Whitehead, own use and personal gain. No attempt to excuse these actions have been made, and despite proper service upon them, because remember, he said he wasn't served this either. Defendants have defaulted in appearance as demonstrated below. Plaintiff is entitled to judgment in favor to allow her to recoup the stolen funds from defendants along with punitive damages for the fraudulent misrepresentations perpetrated by them. Plaintiff previously sought a default judgment. You guys remember that when he said he had the victory? By way of notice of motion, which was denied on procedural grounds. As I told you guys, it was procedure. The case was going on. Plaintiff now brings an order to show cause seeking the additional release of attachment, a preliminary injunction, and a temporary restraining order based upon the extraordinary events that have taken place since filing that motion. Defendant Whitehead has publicly acknowledged the contents of these proceedings and has sought to publicly suggest that he is responding to them while mischaracterizing their context as untrue. Defendants are flagrantly and willfully misleading the public as to the nature of this action in these proceedings. Yet, they simultaneously and continuously default in appearing. Moreover, it is clear that on the facts presented in the annex affirmation of Pauline Anderson, defendants are attempting to dispose of or otherwise conceal assets to frustrate any attempt to recover a money judgment against them. Somebody said they should serve them in church. In New York, you cannot make service on Sunday. Nope. Statements of material fact. The facts of this matter are set forth in further detail in the annex affidavit of Pauline Anderson in the summons and verified complaint, which is dated September 10th, 2021, and the appended exhibits, which are annexed to the Anderson affidavit of Exhibit A. Specifically, the complaint and the affidavit of Pauline Anderson avers that defendants fraudulently induced plaintiff to enter into a contract and perform under that contract by paying the sum of $90,000 and then breached that contract by converting the funds to their own use. Okay, it talks about when it was. Okay, let's go down. So, on May 23rd, 2022, defendant LWI transferred the title of the home located on the Paramus address. Defendant Whitehead for the consideration of $10 as listed in the annex affidavit of Pauline Anderson. That property is now listed online as being for sale with the asking price of $2.999 in a blatant attempt to dispose of assets before a judgment can be rendered in the plaintiff's favor. To date, defendants have failed to appear to answer the complaint, save for a pre-answer motion to dismiss filed recently by defendant Lamore Whitehead. Remember, I told you he got that attorney. That attorney tried to file a motion to dismiss, but I believe under their rules, the court would have to determine whether they're going to allow it because it's so late in the game. So we don't know what the court said about that. So let's go on. Yet, in the public interview on a YouTube channel that occurred on about July 29, 2022, did not tell y'all he needed to be quiet. You got to listen to your attorneys. I said he needs to stop talking. That's it. Defendant Whitehead stated as follows. Question. Now, what about these rumors about that were accusations that a former member who tithed over $90,000 to you at one time? Do you know about the rumor? It was not right. Yeah, so I'm glad to clear this up. There was never a tie to my church for over $90,000. All right. And if you know the way they want to make the court papers look or whatever is asinine. There was a young man that was in my ministry that was in the real estate company where we were doing investment. Him, his family invested the money, but yet you can't take the money for 2 years. And in all actuality, right, he was down on his luck, him and his wife, and I actually fronted him back 40 to 50,000 out of that, right? So when he got upset with me in the ministry and he was mistreating my members and being mean, and I had to get at him. He left the ministry and said, you know what? Give me. He said, give him his money back. And I said, no, it doesn't work like that. It doesn't work like that. Emphasis added. The agreement is if you pull out, you lose a heavy percentage. So basically, he acknowledged there was an agreement all up in this thing right here. When before he said it never was an agreement in the dismissal. If you pull out, you lose a heavy percentage. That's what it is. When you can't just pull out, you can't pull out, or you going to lose a heavy percentage. So they turn that whole paperwork around to make it seem like that they tied it to my ministry, and none of the paperwork have no ministry on it. It has nothing to do with the ministry. They just put the ministry so it could sound good. So I didn't take no money from nobody. It was business. So you acknowledge taking this money and you had an agreement. Let me go on. So they have that in the courts, and my lawyers are handling that, and that's what it is. People sue people of success. That's what don't you? I don't know if you can attest to that or not. Okay. So let's go for it. On July 31st, 2022, defendant Whitehead is reported as again publicly acknowledging the content of the suit in a sermon at his church, mischaracterizing plaintiff as a quote liar, end quote, and stating of the lawsuit, quote, that's what the enemy wants you to believe, end quote. This motion is being filed in less than 1 year after the time for defendant's time to answer or appear expired. A prior motion for default judgment in this matter was filed February 7th of 2022, and that motion was denied without prejudice to refile on July 27, 2022 due to procedural failure to file a proof of service. So we see why, because it was procedural failure to file a proof of service. That's why the default wasn't entered. So his legal argument, his first point was plaintiff is entitled to default judgment. There's a bunch of case law. I'm not going to bore y'all about that. He basically said defendant's conduct entitles plaintiff to an order of attachment. So they want to attach to make sure he can't get rid of that house, because any proceeds, they want to make sure they 90,000 is covered. So he said defendant's conduct demonstrates a clear risk that upon the granting of a default judgment against them, they would attempt to dispose of and conceal the assets necessary to enforce the judgment against them, specifically while having knowledge of these proceedings. Defendants have refused to answer them while attempting to dispose of the only asset known to be in their possession. Were such a sale completed, then it would make recovery against defendants functionally impossible for plaintiff, who cannot be expected to know the disposition of defendants' assets, especially where it is clear that defendants are juggling their assets between corporate entities as convenient. Whew. And then they're asking for an temporary restraining order and preliminary injunction restraining the defendants from further transferring or otherwise encumbering assets as a means of enforcing the attachment of the order of attachment sought above. Plaintiff seeks injunctive relief to restrain defendants from disposing of assets necessary to satisfy a judgment against them. Yep, a temporary restraining order on that property located in New Jersey. And then they talked about piercing the corporate veil. So when you ask to pierce the corporate veil, it's because some people start, obviously, they create corporations, but there really is no separation. So for instance, I start a corporation, but I still can take my little debit card and go buy me an outfit for myself. Like I commingle my funds. If it can be proven that you commingle your funds, then you're not, even though you almost become one and the same, like a sole proprietor with your corporation. So you ask the court to pierce the corporate veil. So if you ain't got it as the person, I should be able to get it from your company. Well, I'm sorry, the other way. If your company don't have it, I should be able to get it from you because y'all basically the same people anyway. Because you don't have no board members, you don't have, you don't have it. You basically run all the shots, right? So it says, in considering the granting of relief against defendants, recent facts demonstrate that defendants have abused the corporate form to seek to evade legal obligations against defendant Whitehead. Specifically, the transfer of real property from defendant LWI to defendant Whitehead following the commencement of the suit and service process suggests a willingness to abuse the corporate form to evade potential liability. The court should therefore pierce the corporate veil to prevent the perpetration of wrongdoing. A party seeking to pierce the corporate veil. So these are the actual elements that have to be proven if you want to pierce the corporate veil. One, the owners exercise complete dominion over the corporation in respect to the transactions attacked. And two, that such domination was used to commit a fraud or wrong against the plaintiff, which resulted in plaintiff's injury. The party seeking to pierce the corporate veil must establish that the controlling corporation or individuals, quote, abuse the privilege of doing business in the corporate form to perpetrate a wrong or injustice against that party, such that court and equity will intervene. And then he asks for punitive damages. He says, plaintiff's first and second cause of action for fraudulent misrepresentation and conversion respectively seek punitive damages. Punitive damages are awarded in tort actions where the defendant's wrongdoing has been intentional and deliberate and has the character of outrage frequently associated with crime. Thank you, Shawana, for the cash. I appreciate it. Love you. Gonna buy my dinner with that. Thank you so much. If y'all want to buy some dinner, listen, I'm working today. Here, punitive damages are appropriate because of the station and role held by defendant Whitehead, who holds himself out as a bishop of Leaders of Tomorrow's International Church and aspires to political office, having sought the nomination of the Democratic Party for the role of Brooklyn Borough President in 2021. The relationship between a priest and a parishioner is, under New York law, a fiduciary one. The relationship between priest and parishioner is a clearly fiduciary as any relationship between two individuals in our society. To hold otherwise would deny the morality and the purpose of religious institutions. Indeed, the definition of fiduciary relationship enunciated by the courts in the Panado case can only be read to include relationships between clergy and parishioner. Look at Langford v. Roman Catholic Diocese, and you see all those numbers right there. If y'all get bored and want to go look the case up. Given the heightened standard of conduct, Whitehead, who was sought out by plaintiff to assist her in securing housing, has misbehaved in a manner which is not merely intentional but wantonly dishonest in line with the applicable legal standard. Accordingly, this court should schedule this matter for a hearing for an assessment of punitive damages against defendants who have declined even to answer these claims while simultaneously seeking the approval in the court of public opinion. Yeah, but y'all know his attorney ain't just let that go down like that, right? He responded. So let me go try to find his response. Let's see. His attorney responded, objecting. Oh, it gets better. Y'all not gonna believe what I'm gonna tell you after I tell you all this. So let me find it. So he does an objection and notice of rejection. So he those are all the numbers you guys see, 32 through 41 are what they're labeled in the docket. So he basically is talking about those. So he says, to the extent that they seek default judgment, giving that defendants have filed papers to cure his default, address Bishop Whitehead's alleged default and dispose of this for reasons fully set forth on record. Further, plaintiff has not shown or demonstrated that she has suffered any prejudice herein. Therefore, this court should not treat plaintiff's bad faith default judgment application favorably. So what he's asking for is a bad faith default judgment because you got served, I guess is what he's trying to say. So these are these objections. He said, defendants further object to the following: rejected documents filed by the plaintiff for the reasons in the paragraphs written below. So his attorney gives a whole lot of reasons. It's number 33 is a memorandum law that was prepared by use of a computer. However, plaintiff failed to include a certification of counsel pursuant to the provision of New York comp codes. Basically, he gave a procedural formatting reason, I guess. That says every brief memo, affirmation, and affidavit which was prepared by use of a computer shall include on a page attached to the end of the applicable document, setting for the number of words in the document and certifying the document complies with the word count limit. That's how it is in federal court where I am. I don't know if that's really how it is there, or even if that's a reason to like literally reject the document, but okay. Number 34 purports to be an affidavit of plaintiff Pauline Anderson in support of her proposed order to show cause, but she impermissibly shoehorned legal points, exhibits, and legal arguments within it. However, an affiant cannot swear to the truth of a legal argument. Then he gives you the case law. Then we go to, he rejected document 35. He said he purports to be an attorney affirmation in support of the proposed order to show cause, but the affiant, and he says the attorney name, who is plaintiff's attorney of record, impermissibly shoehorn legal points, citation, exhibits, and legal arguments within it, and a affiant cannot swear to the truth of a legal argument. So he got the same law there. Then he wanted to strike number 36. It said it purports to be an attorney affirmation of emergency in support to plaintiff's proposed order. Same reason. Number 38 purports to be an affidavit. However, this case is in contract is against the natural person. Thus, plaintiff must submit an affidavit stating that Bishop Whitehead was given additional notice of summons in the manner prescribed. So there goes the whole I haven't been served thing. So he says it shall be made by mailing a copy of the summons by first class mail in an envelope bearing the legend personal and confidential, and not including on the outside of the envelope that the communication is from an attorney or concerns an alleged debt. And he says plaintiff has failed to comply with the provisions enumerated as number 3 and 4 above. Default judgment cannot be entered against Bishop Whitehead with the proper affidavit of notice and full compliance with the provision. So he gave a lot of, looks like, procedural reasons as to why he feels like a default should not enter. So let's see what the judge said, right? So the judge said, wait a minute. Sorry, I'm getting too finger happy on this screen. I'm gonna stop sharing. Okay. So let's see what the judge said. The judge said, upon accompanying affidavit of Pauline Anderson sworn to on September 26th of 2022 and exhibits annexed here to the affirmation of Peter and Riviera, September 23rd, 2022, and exhibits annexed here to the memorandum of law dated September 23rd, let defendant Lamar Whitehead and Lamar Whitehead Inc. show cause before the court, and it got the room number on October 26, 2022, in person. You see that in person? At 9:30 in the afternoon or as soon thereafter, as counsel may be heard, why an order should not be granted pursuant to CPLR section 6201 for an order of attachment against the defendant, pursuant to CPLR section 6311, enjoining and restraining the defendants, their agents, servants, employees, and all persons acting on their behalf from assigning, disposing of, encumbering, or secreting property, including without limitation the property located at the Paramus address, pursuant to CPLR, entering a default judgment against defendant Lamar Whitehead and Lamar Whitehead Inc. in favor of plaintiff Pauline Anderson on the first, second, third, fourth, fifth cause of action of the complaint, Upon such default, ordering defendants jointly and severally to pay plaintiff each compensatory and punitive damages as this court may determine, plus statutory interest. Schedule this matter for an assessment of damages and for such further and other relief as the court deems equitable and just. So basically, he objected in the court. The judge was like, yeah, I think you should probably come in to court on October 26th, and you need to show cause why I shouldn't give them everything they asked for. So he got to go to court in person in New York. But there's more, y'all. I know you can't believe it. Let me go look at some of these questions. Thank you so much for the super chat, Victoria. I appreciate it. Yes, please hit the like button. Thank you, guys. Thank you so much. I would really like to know if one of these three robbers is cooperating there. We haven't heard about the third person. I've been looking. I don't have my ear to the ground. I have gotten zero information on that. Thank you, guys. You guys are going to buy my dinner today, Friday. So, you guys ready for part 3? Say yes. Say yes. Okay. Let me see. Oh, man. I was on the roll here. Wait a minute. Oh, here it goes. So, apparently, y'all see that? Apparently, when Anderson's attorney filed that motion, right? Thank you, Mia. Thank you. When attorney filed that motion, it was on, I'll read it in a minute, but he filed it September 21st and FedExed it to Whitehead. But apparently his attorney filed an appearance around the 19th. So in theory, he was represented. So check this out. Because Anderson's attorney mailed the document FedEx directly to Whitehead, his attorney filed a lawsuit against Anderson's attorney. Y'all, he filed a lawsuit, and let's go over this lawsuit. So y'all, he said plaintiff Lamar Whitehead, okay, is an individual and natural person. The defendant is an individual and natural person. Mr. Riviera is an attorney licensed to practice law in the state of New York. He has his number. Defendant Richter Restro is the domestic professional service limited liability. So that's the firm he works for. Mr. Riviera and RR collectively defendants represent Pauline Anderson in a pending lawsuit. Plaintiff retained attorney Brian Ponder, who filed a motion to dismiss in the Anderson case. Plaintiff's motion to dismiss was filed in the Anderson case by Mr. Ponder on September 15, 2022. Plaintiff's motion to dismiss notified defendant via NYSCEF, which is their electronic system, that plaintiff was represented. As of or about September 15th, defendants knew that plaintiff was represented by Brian Ponder. On September 21st, 2022, defendants communicated with plaintiff directly via a FedEx mailing. On September 22nd, 2022, plaintiff received a FedEx mailing from defendants on the Anderson matter. Defendants breached their duty not to communicate with plaintiff about the Anderson matter. Defendants said duty arose under Rule 4.2a of the New York Rules of Professional Conduct. Defendants' conduct proximately damaged the plaintiff, Whitehead, to incur fees, costs, and emotional distress because he got a FedEx package with the stuff in it, with the pleadings in it. Wherefore, plaintiff demands a jury trial and entry of judgment in favor of plaintiff and against defendant for compensatory damages in amount of $1 million and punitive damages or to be determined by the court, costs, attorney fees, and such others, and further relief that this court deems just and proper. I don't know what to say. I don't know what to say. I have never seen anything like this in my, because a FedEx package came to your house, you are distressed. I'm distressed reading this. That's what I'm distressed about. If anybody has heard anything like this, please let me know, because I ain't saying I done seen everything. Child, he done sued the attorney because he said his client is emotionally distressed from receiving that FedEx package when he knew he was represented 4 days. This Lord, I told you I had a lot to talk about on today. I don't know what to say. I, y'all just as shocked as me. I was reading it like, is this real? Yes, it was filed. Thank you, Ray. Speaking into existence. Listen, thank y'all for the cash apps. I'm glad you guys are enjoying this. If you guys want to donate, you can. What is my? You guys put it in the chat. I don't remember what my doggone cash app is. I'm so overwhelmed today. You said take a breath. Y'all, please hit the like, share, subscribe. Listen, Hunty, I have never seen nothing like this in my life. That's why I told you a trick of the enemy when my stuff wasn't working early. I said the devil is a liar. I had to bind, rebuke, and start over because I was gonna get these documents. I done had this stuff, and you see, I had the hearing yesterday. I've had this stuff since last week sometime, but I just didn't have time to do this. And then this week, everybody had emergencies. So I was just like up all night doing emergencies. But I said, I'm going to get this done. Then my computer and my sound was giving me the flux. So I said, I'm going to walk away for a couple of hours and I'm going to come back with these documents. So what y'all got to say? We got the apartment buildings. We have, so we know what's going on with that. That hearing is, I believe, November 10th. I have to look at my little notes to see when that hearing is. We have this one is October 26th that he's going to have to come in and order the show cause, which is basically why shouldn't they get what they asking for? Come with some evidence as to why you shouldn't be ordered to do all of this stuff. So if he is representing a firm, then why he's suing the attorney and not the company since they gave okay to do that? They try to do both because I think they try to put a little stain on your name for bar purposes. This is habitual. He does shady mess and suits when he's disposed. That's how he bought all the designer stuff. I don't know how he bought it because I'm just as flabbergasted as you guys. And I look at documents all day. You guys know that. And when I saw that, I was like, what is this about? I was like, the attorney. Blessings to you too. Will he have to hire a separate legal team to sue? If so, how can he afford to? My understanding is the same attorney that wrote this is the attorney that brought the lawsuit. I don't know if they've ever been served or what's going on with that, but this is the same attorney. Now, this is the same attorney also that when all this stuff first happened, he was breaking down the Anderson complaint and was trying to help Anderson's attorney like literally emailed him, showed it on a video of him emailing him, asking him to help him, and that attorney refused his help. Next thing you know, he was representing Whitehead. So, and I have that video too. But I usually don't try to be putting attorneys on, on blast like that, as you guys know. But yeah. I think his house, I think what he was saying is the house was in the corporation name, and then I guess he sold it back to himself for $10. The real estate insider talked about that on his channel, and I think Josh talked about it with him as well. So it was something with I'm not as familiar with that. See, that's why he was saying that people knew. That's why he was saying that people were talking about his address, and he made that statement that somebody tried to break in his house and somebody tried to break in his car, and he said because people were putting his address out there, but they like it's for sale, so what are you talking about, like it's out there. Told them feds need to make their move. Well, I don't know. I don't know the feds involvement in anything, so I'm not gonna even try to profess and try to pretend with y'all because I ain't talked to no feds. But honey, it's a lot going on in these streets. Hit the like, y'all, don't cost you nothing. Hit that like button. Yep, that case is still going on with the campaign manager as well. So, yeah. So now that we have that out the way, I'm gonna briefly talk about I don't even know how to transition from that. That's why I was saying, like, I think it needs its own video. So I don't really know how to transition from all the stuff I gave you from Whitehead. So they were asking me about the Cardi B situation. I did look online, and it looks like, remember the last time we talked about it, they asked about getting a supersedis bond. Cardi B's attorney requested a bond before to attach to the appeal to make sure that the money is there. Because the purpose of a bond, as many know that do civil or have engaged in civil, is to make sure. Oftentimes, people do file frivolous appeals. So we want to. It stops people from filing frivolous appeals if you got to pay $4 million before we even gonna listen to your appeal. That's the first thing. Secondly, a lot of times they don't want you depleting your money trying to appeal and pay these attorneys, and then you don't have the money to pay your judgment. So either way, that's kind of hit because that means if you appeal, you need to be coming up with this $4 million to secure your appeal, or you need to come with this $4 million because it sounds like she being Cardi B is attaching to her properties and her assets and is trying to take them. So it's just a messed up situation all around. I don't really have much to say. Like, I want to know your legal analysis. I would be crying somewhere in the corner, like that's where I would be. But I also would have took it down. Like it just ain't that deep for me. You would have said take the video down, not a problem, boss. Because I ain't trying to pay $4 million. But let me show you guys. Now that I talked about that, we did a little commercial break. Let me see if I have some of the stuff I got from today. The pictures. Ooh. So that's this is from this morning. You see it has kind of the wood still out there, like they just kind of started building this. You see the steps going up there. That's from this morning. Let's go look at another one. This is a video. Let's see. This is from today, this morning. So I think that's the picture he probably showed them. If you guys see, there is some wooden steps going down on that one. So maybe that's the picture he sent over to his attorney that has judged that the attorney was talking about. Yep, sure can. I agree with you. Well, apparently there's some for rent signs out there, so they're looking for more tenants out there for those anybody in Connecticut looking for a place to stay. He has openings for rent, apparently. You said it's low vibrational. Oh, you guys are too funny. I don't know what to say. This is a lot. This is just a lot. I understand that I'm trying to look a commercial break. Do you anybody remember come on, trying to shift the atmosphere? Remember Pam from Total? Do you guys remember her? Did you guys see that she said she had a book and she lied about her entire book? Well, not her entire book, but she lied about some of the stuff in there. Does anybody remember the Pam from Total? Anybody on here? Anybody? Oh my goodness, you guys! I can't with y'all. I'm trying to change the atmosphere. Yeah, I seen this. Yeah. All right, let's talk about Pam from Total real quick. Y'all just hanging with, since we up here just chilling right now. Let me let me see. So she did a video recently and she basically said, let me show y'all what she said. That's Pam from Total. Wait a minute. I got so many videos up here. Wait a minute. Oh, now it's buffering. I guess my computer said you're doing way too much right now. Let me see.
Good morning, everybody. I hope that this message finds you well. I just wanted to get in your face for just a couple of minutes, really, really fast. There's some things that I like to share. In 2019, I actually wrote a book called Total Exposure Pieces of Me. And upon me writing the book is about my life and some of the things that I went through. Um, Regrettably, I want to get up here and I want to say to you that there are some parts of the book that I lied. Um, I know that there's nothing that I can do to take it back. I can't go back. I can't go back and rewrite what it is that I've said. But it's time for me to come forth and to speak the truth, especially because I'm going forward in my life with God. I'm looking to be a better person. I'm not looking to be a liar anymore, to walk in those shoes anymore. And I've known that I've known this for a while. I knew what I did, and I hid it. I knew that it kept coming up. I didn't want to have to come and confess this, but I truly believe that there are some things that have to be openly said because of it was openly done, and it was openly done. So many people read the book, so many people saw me on interviews, expressing the book, and all of these things, but had no idea that the integrity of the book was lost because of me lying. And with that, I apologize to everybody. Please forgive me, to my family, to my New Life Now family, to my church, to my friends, those who brought the book and really believed everything that I said. And at this point in my life, like I said, for me to be able to go forward, I had to, and I have to come to this place. Was it scary to get here? Absolutely. But I'm moving forward. And I thank God that I don't have to be under guilt and shame anymore. So please, for those in my family, you don't have to try to defend me at all. This is something that had to be done. So you don't have to try to defend me. I'm sorry that for putting you in a place to feel like you would have to defend me. But the truth is the truth. And I had to come to the table with it. And I'm thankful to God for the opportunity to be able to do it. Thank you all. God bless you all. And again, I apologize for what it is that I have done. And I'm moving forward now. No longer am I looking to live in a place of lying. And so, God bless you. Thank you so much for hearing me out.
What's she even talking about? Did she tell you? And I know this ain't got nothing to do with the law, so this gonna be our outro. Did she say what she did wrong? First of all, I didn't know you had a book. I don't even know what you talking about. You ain't say like what in the book did you lie about? We supposed to go through the book and then say this look like it's fabricated. This might be real. Like how you gonna confess to something but then don't tell anybody what the heck you did wrong? It's something like not. I'm lost. What are you confessing? What did you do? What? What did you do? You lied about what? Is there somebody else that said something and we missing that part of the story? Like, what's going on here? Somebody said it's a play. It's a ploy to trick us into buying her, but I'm not buying it, so that ain't gonna happen. I wouldn't even know what you're talking about. Like, even if I bought your book, what am I supposed to know? Like, am I supposed to DM you and ask you, is this segment true? Which chapter, verse? Like, what are you talking about? Anyway, that just irritated me when I saw, so that's why I had to that's why I just had to ask y'all. I don't know if you guys saw it, but yeah. But anyways, it's been fun as always. I hope you guys enjoyed it as I did. And I hope, see, we had documents for everything. So I hope you guys, anybody that's watching that has not watched it from the beginning, please catch the replay. Thank you again to all the super chats and the cash apps. I appreciate it. I love each and every one of you guys. We'll be back if something, big happens because it has been a big week. But yeah, that's what's going on in the world of the Whitehead. And that's it. I hope you guys have a good weekend. Thank you so much. I hope you have a good and amazing weekend as well. I'm going to talk at you guys next time.